Hi, perhaps we better kick off and welcome to everyone who's joined. There's a few that are coming later a bit, but I think we can kick off. Today, my name's Jim Doyle. I'm from Doyles Construction Lawyers, and we're here to share an hour of joy and entertainment by looking at latent conditions in the construction industry. So I'm presuming you've all had good and bad experiences with those, and we'll run through some of the principles and then look at some of the cases and the inspiration that the courts have provided for us. If you've got questions, you can either put up a hand and try and get them answered during the session, or alternatively reserve them for the end. So if we kick off in that situation, we might start with looking at latent conditions. Latent conditions are interesting because they're conditions that aren't fully provided to everyone's satisfaction necessarily in the contract. We'll see how the laws develop from a tough-on contractor point of view to what might be described as more even-handed in today's construction industry. And that's why everybody from the contractor or the principal or the superintendent have to be on their guard to make sure that they're connected with some of the issues that are inherent in latent conditions. The situation is we construction lawyers, we deal with construction disputes almost all of our time, and we enjoy the challenge of translating the pieces and promises into the future into real events. So I suppose the circumstance that we want to cover today are what are latent conditions, what do they mean, how are they important, how do they work in the industry, the law around latent conditions, because the circumstance is that latent conditions can be a big part of the job. The increasing legislation around latent conditions, the ACL and the unfair contracts legislation now is raising new issues, and one has to keep up with the flow of justice as it varies over time. And latent conditions often give rise to big disputes because fundamentally they're not in the principal's budget, and they are usually not in the contractor's budgets as well. So everybody is put to a challenge as to see what is going to be a solution that works, or is going to be imposed by the courts or an arbitrator if push comes to shove. The issue is that with latent conditions is that they're susceptible to causing great waste. And that's a factor of construction industry that must be looked at when you look at latent conditions. If we have a contractor who hits hard rock, he says, well, this is my way to recover some of the tender price that was underquoted, so I'll charge a heavy piece of rate per square metre for this hard rock. The principal, on the other hand, says, well, it's hard rock, the situation is it's not my responsibility, he should have woken up to that. So the principal doesn't really engage with that latent condition, nor really does the contractor. Months go on, that delay and that cost associated with the hard rock is enormous, and nobody's taken ownership of it. So the circumstance is that when that happens, there's a great propensity for inefficient methods of removal to have been grasped by the contractor, and a disclaimer of all liability by the principal. It's a recipe for disasters if they're not well managed and well handled by reasonably sensible people. And the other aspect is you've got disputes, you've got commercial considerations in respect to the situation, and you've got to work through those against the background of what we'll discuss about latent conditions. The first point one stops and thinks about is, what is a latent condition? I suppose its opposite is a patent condition. That is a condition which is obvious, but a latent condition is in some way hidden and unrevealed. And the circumstances, that can either be the condition itself, that is, whether there'd be hard rock there, or alternatively, the hardness of rock. And given the propensities of nature to throw up all sorts of issues, I've come across an issue where the rock was soft and was able to be cut easily, but when it dried out and had to be lowered by a few centimetres, it turned out to be rock hard. So the idea is that the conditions are hidden and they're therefore not planned for in either the contractor's method of working or his cost burdens, or the principal hasn't really thought about it, and by definition, effectively, the principal's consultants haven't thought about it in the degree that in retrospect would have been required. So that's a latent condition, and it can be any sort of aspect. It could be an aspect of rock, it could be an aspect of contamination, it could be an aspect of access to the site, or restrictions on some activities on the site might come within this general aspect of latent conditions, depending on the terms of the contract. The other aspect is sometimes you get latent conditions which have been contemplated but not really provided for in the contract. You might have a contractor who's thankfully put in his contract, no hard rock has been included in my contract price. And so the situation is they're sort of thought about, perhaps suspected, but not really provided for. And depending on the skill of the draftsman and the degree to which he understands the conditions which are or could be entertained, you might have some room for debate and consideration. The general aspect, though, is latent conditions ahead and unforeseeable based on the information reasonably available before the contract. Example, buried asbestos, not revealed in prior surveys. And patent conditions should be the ones that are obvious, rubbish piles visible at tender work through. The situation, though, is you've got to be careful, because a latent condition can be sort of made by comments and by information provided in addition to a site survey. For instance, on the Sydney airport, I had a contractor client who claimed that the material he encountered was unbelievably difficult to compact. And he thought that that was unforeseeable, because when he'd gone to the tender meeting, he had walked around the site with everybody and he'd pointed to some test pits which had been opened and said, how long have they been opened? And they told him, oh, only a couple of weeks. And he looked at the deterioration in the output from the tender pit and said, oh, that's all right, if they deteriorate that much, they must be of a certain nature of compactability and general condition, so I'm happy to tender. But later he found out that the material wouldn't compact, and further that the test pits had been open for a year or more. So again, given that that was misleading conduct, he put in a claim, and eventually it was settled. So you've got to be careful about what the information is around what is available for inspection. Why they matter: cost blowouts, extra excavation, dewatering, program delays, disputes over entitlements and liability. The circumstances, it sometimes covers what contractor due diligence was carried out, whether he investigated the site and the information around the site that was reasonably available, and also if he investigated what the principal had provided and whether and to what extent that was qualified. So important sort of aspects. The other aspect to deal with this is the traditional common law position is that the risk lies with the contractor in lump sum contracts, unless the contract expressly states otherwise. When we look back at that, we sort of find from a risk allocation point of view that primarily latent conditions, we treat rock in that situation for demonstration purposes, lies, you would think, with the owner of the site. That is, it's his site, and if he's got rock on it, he should pay for it to be removed if he wants to do something with his site. So it could start from a situation where the risk lay with the landowner, the principal. However, the situation is the courts come to the view that if a builder comes in and says, I will build this building at this elevation and to this dimension, then he takes the risk of making sure that that's delivered. And effectively, he took the risk of the latent conditions. So we start from that fairly tough common law position, and then we'll see as we advance into the future that the law is adjusted over the period to come to a more sophisticated and generally more fairer basis of risk allocation. So the situation is contractors expect relief. So people have got to the stage where they don't think that they accept all risks when they contract, and they wish to have them estimated and correctly priced. The other aspect is that if a principal said, well, I don't care what's on my site, I want you to take care of it, whatever it is, then it's uncertain whether he'd get any competitive pricing. Competitive in the situation of comparing one contractor's efficiency with another, because in a lump sum tender, that would mean that a contractor who is conservative would allow a lot of money for the risk of latent conditions, whereas a contractor who is more risk tolerant would take a less margin for that risk, in which case you're altering the comparison between their efficiency on what might be 90% of the contract. So there's a motivation and a reason for principals to try and restrict the amount of risk that is associated with latent conditions when they go out to get a competitive tender. Common examples, you've got buried contaminants, fuel, asbestos, underground services, high groundwater tables. The situation is that it's important that you are aware of those risks on any particular project and have got contractual provisions designed to sort of manage that risk as fairly but as firmly as possible. For instance, one contractor client of mine thought that he had achieved a substantial success because he'd been able to put into a contract that if high water tables were expected, he would get paid so much a litre for pumping it out of the excavation. Fortunately for him, he ran into a lot of groundwater, and per litre extraction was very efficient and very cheap, and was well under the cost that he had put in his tender. He thought that was a good idea, and eventually he settled it at good terms and everyone went along happily. But it shows up a weakness that if you don't show a price and an expected quantity and are able to build that into the tender evaluation, then one can get some unexpected surprises. So if we look at the common law position, we say that the courts are not naturally happy with reallocating risk based on principles, vague principles of fairness or hardship or anything. They're looking at the common law. They're looking at their pound of flesh for each provision in the contract. So the first question you've got to do is to say, is there a specific latent condition clause? If there is, then there's a situation of applying and excluding it, and actually seeing whether the risk is on the contractor or the principal under that specific clause. The other aspect you've got to look at are exclusion or disclaimer clauses in play. Has the contractor said, I exclude rock from my tender, or has the principal said, I disclaim any responsibility for the information I give you, and you must do your own searches and accept all risks of everything? So that's important. The other aspect is you've got to say, well, if the principal data has been provided, was reliance on that reasonable? Did the principal somehow induce you to take a position based on his data that he's given every tenderer to tender on. The default sort of position of responsibility is probably demonstrated by this case in 1929 of Walker versus the Council of Randwick. And there, the contractor encountered a greater volume of rock than shown in the tender documents, and he sought an additional payment. And the question was he entitled to a variation? And there, the situation of the judgment was no. Times were tough in 1929, you might remember, there was a depression around the corner, and the court came up with a solution that the contract was an entire contract to build the wall for a fixed price. And the plaintiff's obligation to complete the works at the agreed price was not affected by the alleged understatement in the plan, and therefore he's not entitled to pay payment for extra work occasioned thereby. So one has to start with a reference point saying, if it isn't in the contract, then you might be exposed as a contractor. That is developed because the situation is it was re-argued back in 72, which where the contractor claimed adverse ground conditions justified extra payment, and they wanted to see an implied condition. They wanted to imply a condition into the contract that said they should be paid for it. And the circumstance then is the justice said, no, the party who's contracted to carry out honour under land is bound to satisfy themselves the nature and characteristics of the land, both on the surface and below it. So you've still got that principle running with and providing a foundation stone for your analysis of latent conditions. The situation then was that the question arose again in 72, and the circumstance there was that, again, they relied on geotechnical data in the tender documents, which turned out inaccurate. And was the Commonwealth liable for the misstatement involved? The situation you've got to remember, at this time, there wasn't a misleading and deceptive restraint in the Trade Practices Act, so this was a matter decided on the contract. And there, the judgment was that he'd failed to convey to the contractor that there was no responsibility accepted. What he said was, and in the more detailed thing, it purports to claim responsibility for any interpretation included or conclusion drawn by the tenderer. So the formulation of that disclaimer clause was not too accurately done. Instead of disclaiming responsibility for the data, they disclaimed responsibility for the interpretation of the data. And again, the contractor was successful. The other aspect that you've got to look at when you're dealing with some of these latent conditions is the issue of, does a latent condition destroy the basis of a contract? So say, for instance, you're got a contract to build a substantial underground tank, and the situation is that everyone thinks that it'll be easy digging in firm clay, and it turns out to be rock hard rock. The issue is, does that sufficiently disrupt the contract to make the contract just not applicable to the job? Well, some aspect can be judged on that by the case of Godolphin versus State Rail Authority in 1982. And the circumstance there is that a change had occurred in the contract where the work hours were severely restricted by a court injunction. So everyone expected them to be able to work 24 hours a day, and they were restricted to, say, something like 12 hours a day. The question is, was the contract frustrated? Did the whole purpose of the contract and the performance that was called in respect to the contract radically different? And the court decided it was. It said that frustration occurs whenever the law recognises that without default of either party, the contractual obligation is being incapable of being performed because the circumstances render it radically different from that which was undertaken by the contract. So again, it's something to be looked at in respect of latent conditions. If, for instance, you are asked to do to build a pier on the basis that the foundations were of rock. And in fact, the foundations were of a shifting sand, and the whole purpose of the contract couldn't really be performed. Then you might dial up Godolphin and seek to say that the contractor was frustrated, and as a contractor you weren't bound to perform something that was radically different from the original contract. The situation is that again, the same sort of issues are raising in Tees Services versus Mirvac, and there the contractor encountered again soil conditions requiring excessive excavation. Was there an implied entitlement? And the situation is the judgment was no. That was Justice de Jersey, who did quite a lot of construction litigation and was pretty sharp in his analysis. And he said the appellant contended would not otherwise bear this construction, a term should be implied. So that the full remediation might not be possible safely, efficiently or economically. By the express terms of the contract, the applicant is obliged to secure the result efficiently and safely. The latent condition clause means that the appellant is entitled to no extra payment because of the terms. So there, the hard rule at the base of the court's approach to these matters is again reinforced. However, the law as it advanced continues on, and we have the case of Abbey Group versus the Sydney Catchment Authority. And this was where Abbey Group were awarded a lump sum contract to construct a new spillway at the Warragamba Dam, and the tender document stated no plans existed for the outlet pipe, but in fact a 1951 plan did exist. So there the tender document said we have no information, there's no plans, and in fact they had held the plan in their hands. Unexpected excavation was required, as circumstance 180,000 cubic metres versus 24,300 cubic metres expected. The contract expressly allocated latent condition and documentation risk to Abbey Group. So the big issue there was that by this time there was fairly established the misleading and deceptive contract prohibition under the Trade Practices Act. And could that conduct override the express risk application? Well, the Court of Appeal found for Abbey Group the omission of the 1951 plan was misleading and induced the contract. The Sydney Catchment Authority was liable despite the risk allocation clause trying to allocate that to Abbey Group, and the damages awarded, 7.5 million for excavation, carried through. So here we have the law adjusting the allocation of risk and responsibility by shifting to a situation where if you mislead someone, then they suffer a disadvantage. You're likely, if it's in trade or commerce and you relied on that, to have a square up. So it's important in these cases to have a look at the clauses which are going to apply if you use some of the standard contracts. We've extracted some of them here, and they have in lots of ways familiar situations, familiar concepts, familiar application that they're bringing to bear with these issues. The scenario is that if you look at AS 2124, it's physical conditions on the sites or its surrounds, including artificial things, but excluding weather conditions, which differ materially from the physical conditions which have reasonably been anticipated by the contractor at the time of the contractor's tender. And that's if he'd done 1, 2, 3 aspects of inspection and due diligence. And it also provides that any other conditions which the contract specifies to be latent conditions. So the latent conditions depend upon what should have been reasonably anticipated by the contractor at the time of the contractor's tender. So the concern is, and the other clauses marginally vary, is the concern is to sort of say, right, look at these terms and see what they involve. Now, the circumstance is that you'll see in GC 21 that there's a wider definition of what's excluded for weather conditions. So including subsurface conditions, but excluding weather conditions or physical conditions were a consequence of weather conditions. So again, if you've got a flood on site, then the circumstance is that you might not get any latent condition for that. So it's important to read the clause, and it's important to evaluate the risk. And if you are in doubt at all, you should endorse the contract just before you sign it, and the other fellow signs it, and make sure that it's clear that it excludes a risk that you don't want to carry and that you haven't put in the tender. So there's nothing like if you get caught with a latent condition occurring and a need to get compensation, you should have a clause in there that says, like, my tender does not include any provision for hard rock or bad weather, or something of that sort. And it's better to have a badly drawn clause than no clause at all. The other aspect when you come to consider what a latent conditions is, you can have a latent condition which is simply an excessive condition which has been accumulated in the contract. The contract can provide, for instance, that, as in this case of Downer Constructions, that an inflow rate. So it said inflow rates, of 3 metres per second or whatever it is, are included, are the contractor's responsibility. So that's okay. That shows something. The contractor can provide for that risk and tender on that basis. But the situation here is, in this case, in the New South Wales Court of Appeal, Nicholas J said, in my opinion, the inflow rates encountered were far higher than and differed materially from those that should have been anticipated by a prudent, competent, experienced contractor. The situation is, then he went on to say, the presence of an extensive horizontal shear zone with significant groundwater inflows should not have been anticipated by a prudent, competent, experienced contractor. So he found those features differed materially from the ground conditions that should have been anticipated by a prudent, competent, experienced contractor. So there we're seeing some subtlety in the analysis of latent conditions, and the court's being prepared to look at the latent condition and compare it with what should have been expected. And an excessive amount of inflows in this case gave Downer some relief. What we've got to look at is the laws affecting latent condition. If we return to Walker and Randwick, where Walker was told that he'd have to build the wall no matter what, we've then got Section 18 of the ACL, it's now Schedule 2 of the Competition and Consumer Act, misleading or deceptive conduct. A person must not, in trade or commerce, engage in conduct that is misleading or deceptive or likely to mislead or deceive. Most times in construction, not all, but most times, you can exclude the deception. Most people are not trying to fraudulently sort of rip anyone off. They're just misleading people, and misleading doesn't have to have a motive. You can mislead a person even though you tried to tell him the truth and tried to give him an accurate analysis. The important aspect of that is that it's a statutory provision that overrides the provisions of your contract, and that even exclusion clause which says, no, even if we mislead you, you can't sue us, don't generally override Section 18. So the aspect is it's important that this responsibility can't be excluded by contract, and that makes it particularly powerful in the hands of someone who's been misled. We've got to look, though, at how this applies and what you've got to provide to get this to work in your favour if you're a contractor. Firstly, you want a party to the contract making a representation. So from a contractor's perspective, he wants the principal or an agent of the principal to make a representation. And it's important that if that representation is made, that you've got a contemporaneous record of it. The other aspect has to rely on that representation. There's no point if somebody says, well, look, this project is as easy as pie and there's no ground conditions anywhere around. If the other party says, well, I think you're talking rubbish, I'll go and do my own inquiries, then the situation is he wouldn't rely on that misrepresentation. And then you've got to get and prove that the misrepresentation turns out to be false. So they're the three basic characteristics that you've got to apply if you're looking for a square up under Section 18. That's demonstrated in this case of BMD major projects in the Victorian Urban Development Authority. There the judge said that BMD contends, and he accepts, that the exclusionary disclaimer clauses cannot override the statutory provision against misleading and deceptive conduct or permit the grant of appropriate statutory relief where loss of damage is, as a matter of fact, caused by a convention of Section 52. So the situation is the statutory provision overrides any contractual provisions. He also accepts Vic Urban's submission, on the other hand, that BMD had not established reliance on the alleged representation about the estimated quantities of fill or the information provided concerning the makeup of the stockpiles during the tender process. The BMD had said in correspondence that it used the measure resulting from its own calculations in its tender. So it's a bit of a mistaken attitude of BMD, perhaps, not to accurately record what they relied on. So while they might have had their own measure, the circumstances it would be appropriate to take into account the information from the proprietor, and if it was incorrect, and if you did take that into account in your calculations, it might be useful to ensure that you had established that fact if you're mounting a claim. The other aspect is that parties have tried different angles to recover for latent condition problems. One is Walton Constructions and Illawarra Hotel. The situation is that there the superintendent, engaged by the principal, failed to grant sufficient EOTs and variations. So the situation is that they said, which could apply to latent conditions, they said, well, is the principal in breach for not ensuring the superintendent acted honestly, fair and reasonably? And could this lead to time being at large and obviously recovery being obtained? And McDougall J said, yes, even if the superintendent acted honestly and fairly, failing to make a reasonable determination breached the contract. So there the contractual terms gave the contractor a right to have those assessments revisited and to cover the damage that was involved. So it's another way perhaps that in a latent condition situation where perhaps the superintendent didn't recognise that latent condition, but he was under a duty to make reasonable valuations, that you might recover under that aspect. The other aspect is consultant liability. So here the Lane Cove Council had engaged Michael Davies to design a stormwater detention system. They failed to detect a latent subsoil water condition, resulting in site instability, project failure and damages. Was he negligent? Was the risk reasonably foreseeable? Did it fall within a consultant's duty of care? And the Supreme Court held that MDA had breached its duty of care. A consultant contractor should have conducted or recommended adequate geotechnical investigations. MDA is liable for the council's loss arising from a failure to detect the latent condition. One aspect of that to talk about is whether or not the negligence of the contractor would entitle the contractor to recover damages if the contractor had been involved in loss on that project. A couple of things to consider here. One is that the consultant could conceivably be liable in negligence. That is, he owed a duty of care and he didn't do the duty appropriately. The problem for the contractor there is that the courts have generally found that the duty was owed to the principal, but for a consultant it's not generally owed to the contractor. So the contractor would have some difficulty in pursuing the consultant in negligence unless he had some sort of special advice or special relationship or aspect. However, if the consultant's design drawings, which were then communicated to the consultant for the purpose of quoting, misled the contractor may have a chance to recover against Michael Davies, because he would go under section 18 of the ACL and say, I was misled by your plans, and accordingly, you having misled me, you're responsible for damages. So all of these surround the central issue of latent conditions and trying to get a recovery by one party or another who's not had a good run. The situation is then, you've got an idea of the trade practice history where it's come in 1974, and the situation is it provides a very important standard of commercial morality. That is, you shouldn't contract on the basis that you mislead people, and that if you do mislead people, fundamentally you'll be responsible for the damage that's caused. The important aspect of that is also added to by the unfair contracts legislation. The unfair contracts legislation is recently in full force. The approximate date, November last year, and that enables the court to declare that a contract contains, a standard form contract contains unfair provisions, and if those unfair provisions are struck down, then that allows recovery. So say, for instance, a contract was written on the basis that the contractor is given no information about the subsoil conditions, but he's required to take all of the risk. And that was a standard form sort of contract distributed to everybody. It may be that the successful contractor, having run into hard rock, will find that there's a problem with the rock. He wants compensation. He says that is an unfair clause and that's void, and therefore there's no contractual provision that prevents my recovery. So it's important to keep alert to the contractual arrangements that are being affected by legislation. And some of these, we can expect a little bit more of them in the next 3 years or so, because some of these are instigated by the current Labor government at a federal level, and that there may be a momentum in terms of sorting out some of the legislation that operates on contractual claims. The other aspect about it is that you've got to look, when you're looking at misleading conduct, as a recent, not so recent example, you can have 3 boreholes and they both record reasonably similar soil profiles. And the natural tendency is to draw a reasonably straight line between each of the boreholes. However, if the situation of the soil profiles turns out to be from a high point to a low point to a high point to a low point to a high point, the situation is you might connect up the boreholes in a nice straight line, but when the contractor actually got to do that work, he'd have to change his method depending on whether or not he was digging in sand or digging in clay. And in example, in the Brisbane airport, the contractor made a successful claim on that basis. That is, he was required and misled into thinking it could be a constant operation, which would be very efficient, or else a constantly changing operation, which was very inefficient. The aspect, as we've covered, is that the statute, the misleading restriction in the ACL 18 is not able to be contradicted or excluded by contract. It's possible to exclude, given clear situations, of the common law duty of care. One can have a contract fundamentally which says that there is no duty of care attaching to X in respect of Y. But the situation is, in respect to the statute, a restriction on no misleading conduct, it's not possible to achieve that end in all the circumstances. The other aspect is that it is possible to gain significant protection for a principle if you carefully explain the limitations on the information you're giving. So if the information is rocks at 3 foot, that's fairly unqualified and is likely to give rise to some liability. But if you said, look, we don't know what the rock level is, but we have taken one rock sample and that occurred at 3 foot, then the situation is that it might be a warning to the contractor to take proper protection. We've dealt with frustration and that aspect, and the situation is that's an associated sort of legal doctrine that might come to rescue the right sort of contractor at the right sort of time. And the next one was pro-build and DDI, and DDI was delayed by variations directed after the contractual completion date. It failed to claim EOTs in a specified time, the contract allowed Proudbuild to unilaterally grant EOTs even without a claim. Was there a pro-bid obligated to exercise that discretionary power? Was there an implied duty of good faith? The New South Wales Court of Appeal held that pro-bid was obliged to exercise discretion fairly and honestly, and failure to do so would breach an implied duty of good faith and trigger the prevention principle. So there's a situation where, again, you might apply that to a rock claim or a water ingress claim or a contamination claim. So, aspect. The situation is that contracting a latent condition, some contracts may seek to exclude claims for delay at a latent condition. So you've got to be careful in that respect, in the sense that does it exclude some aspect of it. You'll notice in some of the standard clauses there's a exclusion for latent condition costs if they're notified more than, say, 28 days after they've been encountered. So you've got to look at those and look at the particular contract to see how they'll apply. But the other aspect is you'll get pre-negotiated variation rates. So someone says, in respect to latent conditions, well, it'll be $10 every tonne of hard rock removed. Well, the situation is that if you're determining a reasonable rate or price, then what the court said in this Lucas Earth Movers Proprietary Limited, Anglo Gold Ashanti, is you've got to have regard to all the material circumstances. And these will include the nature and complexity of the variation, the resources to be applied, giving effect to it, and the costs of performing it. The fact that an account has taken of time-related costs in fixing the rates for these items of work tends to suggest that it will also be appropriate to take account of time-related costs in pricing variations, where that's not provided for. So again, with latent conditions and the standard clauses, they'll say reasonable price or reasonable rates for the work. You've got to look at the full circumstances, and from a contractor's point of view, make sure that you've articulated all of the challenges in undertaking the work. Otherwise, the latent condition might be paid out at half the normal or half the reasonable rate. So it's important to articulate the difficulties with a latent condition. And they are fairly legend, because often a latent condition doesn't demonstrate itself in a nice, convenient and casual way. It occurs in bits and then reoccurs and then is a significant force. So the idea of that acting on the efficiency of the construction team, the efficiency of the equipment used to calculate it, is of importance and must be investigated and presented properly to get a proper claim at a proper rate. I was involved in a power station in Fiji, and on the contractor side, they couldn't understand why their team wasn't achieving the scheduled rates in the rock that they were encountering. And it took many months of investigation and expert opinion to find out that there was a major flaw in the rock, and it was altering all of the levels of difficulty that the contractor was handling. So again, it's important to understand the restraints that are being put on your performance by a latent condition and make sure that you have properly priced it. The other aspect is to realise when you're talking about foreseeability or costs that should have been taken into account or not, the situation is that foreseeability is an objective test. You're trying to find out what a reasonably competent contractor would have foreseen. It's important to make sure from a contractor side that you have presented the approach that you've taken prior to tendering in a competent and professional way. You don't want a shuffle of papers with scatty calculations on them. You want to show that you've approached it professionally. You've got a clear record of what was taken into account and how that was used to generate the tender in order that you can mount a claim at a later time. The other aspect is you've got to prove when you're putting in a latent condition claim that it really caused the loss that you suffered. That is, you've got to sort of trace it from the water inflow or the contamination that you've discovered, and then map out how that caused the cost you're claiming. You've got to show that it wasn't foreseeable, that you couldn't have expected it, and then you've got to trace out all the delay. It's important to do that because otherwise in a latent condition claim you can have weeks of confusion, but there are also weeks of delay. And unless you show that you're acting competently throughout that period, you won't get the contractual input, the compensation that you deserve. The other aspect is in notifying the claims, you should take into account the legal entitlement clauses and make sure that you've ticked them off. That is, that you've taken any measure to reduce the delay, that you've done this and that and responded to the superintendent's request for information promptly. It's important to make sure, if you've got a substantial claim, that your compliance is red hot. Again, if you're on tender and pre-contractual representation, you would succeed if you can prove that the reliance is reasonable. There's a sensible piece of information given to you there. Perhaps the principal had knowledge or failed to disclose contrary information. So the situation is that it would be important, if the principal has lots of information about it, that the fact that he said he'd given you all and he hadn't would be very important. The other aspect is the reliance has got to cause the loss. So if you're saying you've had to change your whole team to deal with this problem, then that's got to be carefully done. And of course, you've got to look to meet your provisions in the contract. We've talked at some aspect about cost impacts and time impacts, delay to critical path. If you're doing excavation, usually you've got work to follow. That program sequencing is important. You've got to send subbies away and get a different team of subbies in for maybe months, and then you lose some of the subbies that were going to carry out the work, and you've got to go and get more and perhaps more expensive subcontracts. The aspect of independent experts in latent condition disputes is important, because the situation is that, one, if you're sitting at hard rock or you've run into a contamination, it's best to get a contamination expert to report on that contamination and to classify it and to what sort of remedy is required to be applied to it, rather than you just making independent sort of or random assessments on your own, and realise if it goes any further, you're going to have to prove it in court. And the benefit of a consultant who's actually looked at and classified the contamination before it was removed and perhaps certified the remediation of it is going to be a lot more persuasive than someone brought in 3 years later to give his opinion. So the expert evidence should be independent, of course. It's not much point getting your cousin to do it because it won't be accepted in the fullness of time. It's based on objective analysis. Again, you've got to look at experts and say it's not only beneficial if they come to the right conclusion, that's to be encouraged, but it has to be something where they can show their analysis that's led to that conclusion, because the court will be much more likely to be persuaded by a legitimate and logical explanation than by a random guess. And it's also got to be consistent with the contractual framework. That is, if the contractual framework restricts the recovery in some respects, then the expert should be aware of that and should be able to make sure that if the contractual framework requires a certain characteristic to be demonstrated, that he's looked at that characteristic and persuasively presented the reasons why that characteristic is present in the situation. So the other aspect is there are time bar clauses in most construction contracts, and on a percentage basis they're probably mostly unfair. However, the cost of complying with them completely is far less than the cost of contesting the claim later. And one has to have a procedure whereby one is able to advise claims, and if they don't turn out to be significant claims, withdraw them later on or settle them for some sort of drawing a line in the sand process. But it's important that you comply with that, because otherwise you can lose the whole claim. The other aspect is that there's a prejudice to the principal in not being advised. The courts are overly sensitive to this. They say, well, the time bar is in there so that the principal could sit down and consider what he would do then. Well, I think it's overly sympathetic, because this principal usually knows exactly what's going on, and the fact that he isn't formally notified really doesn't increase any costs or remove any alternatives that he might have considered. But the courts are very keen to make sure that that time bar is enforced in order to protect the principal. You should issue early notice if necessary, reserving your rights to claim, but saying, look, you're on notice, and follow up with the supporting details. Some of the claims require you to follow that, but in any event, you should follow it up with more and more detail and get to a situation there. I wanted to then deal with drafting effective latent condition clauses. I suppose one should have, when one comes to drafting a latent condition clause, a concept of what would be a perfect clause. And to my mind, a perfect clause would specify precisely the ground conditions said to be encountered and define them, and then observe throughout the construction the actual conditions encountered, and then had an agreed or a reasonable provision for the difference to be calculated. But latent condition clauses are always a little infected by the principal trying to get a bit of something for nothing, and when a latent condition is encountered, the contractor has a natural desire to sort of restore profitability to the project, so that gives us a creative tension in latent condition clauses generally. But it's important to define the latent conditions and the trigger events. It might be that inflows to 3 metres a second are fine, but if you get to 16 metres a second, then costs increase. set procedures for notification, inspection, joint inspection and entitlement, and show how cost and time packs are going to be assessed. It's better to say, well, if the latent condition is encountered, the time extension will start from the day of notification or when it was encountered, and next it'll end when that's fully resolved, and allocate the risk for certain particular types of conditions. So if you, in some residential contracts, I've seen the contractors take awesome responsibility for very hard rock, mainly because they've got massive equipment able to deal with it. You've got to make sure who bears a risk for various types of latent conditions. And the situation is, if you can include a baseline site data as part of the contract saying this is what is to be expected, to my mind that might give you a foundation to have a latent condition clause that doesn't end up with the Supreme Court. The contractor due diligence, you've got to conduct thorough site inspections, review the geotechnical and historical site data, utilise records and surveys, engage geotechs, and confirm assumptions and qualifications in your bid. If you haven't been able to investigate the bottom half of the site, then say it. At least it will prevent you from picking up some awesome responsibility. And in these days of enlightened entertainment, there's usually post-tender negotiations, in which case, having reserved your point on the lower part of the site, you might then be able to discuss that with them and perhaps agree some sort of testing process by which that could be detailed. So the situation of a principal's disclosure obligation: provide all materials, identify site conditions assumed in the design, avoid selective disclosure, don't try and only give them the good bits because the good bits might mislead, and ensure your reports are current, because if they're not current you may not have got the most recent information in them. And you can include disclaimers, but be careful of not misleading. Role of the contract administrator is to early detection, to keep up with things and make sure things are going. Managing claims, make sure you're prompt and on detail. And oftentimes it's latent condition claims are efficient if they can be settled fairly quickly, because then if they're settled and the contractor is going to be paid a particular rate for extraction, he knows he's got the responsibility back on his shoulders, he knows he's getting paid for it, he there can produce an efficient and effective method of responding to that condition and deliver a better result for all concerned. I think that covers the matters that I wanted to cover today. There's a few pitfalls I'll mention to conclude. Failing to give timely notice. It's a disaster for a contractor not to give notice, and you should be able to give notice without raising too many problems, and with an idea that you're still working on the problems to reduce them as far as you can. Incomplete or poor site investigations, it's amazing how an extra few thousand in bore logs would have helped everyone during the job. And latent conditions have a big tendency to cause big delays, which worries your insurer, worries everybody, and then if you haven't done the inspection and haven't spotted your contamination up front, when you reveal the contamination has been spotted to your financier, and the situation is that it hasn't yet been fully surveyed or costed, then the financier might cut and run. And assuming risk allocation is balanced without checking the clauses. So on that basis, I'm happy to conclude with those thoughts on latent conditions.